Hello, on this episode of On Subrogation, we're going to discuss what to do if an individual files bankruptcy in the middle of your subrogation efforts. I'm Kim Rathbone, your host for today. Now there's two different types of bankruptcies that are most common for individuals. One is a Chapter 7 bankruptcy, and that's where the assets that are included in the plan are discharged. And one is a Chapter 13 reorganization of an individual. What's most common in those is all the debts are consolidated and a small portion of those are repaid in a 3 to 5 year plan. Now, if it's a Chapter 13 or a Chapter 7 asset case, then there's the opportunity to file a proof of claim in order to recover. So you file the proof of claim document in the estate, and the trustee for the bankruptcy consolidates everything together and decides what portion of your claim is paid over the years. But what happens if you have a Chapter 7 no asset bankruptcy? Well, then it's really a waiting game, and the best thing that you can do is try and find an exception to the Chapter 7 bankruptcy and a way to proceed. A lot of times people will ask, should I follow the Chapter 7 bankruptcy to make sure that everything is discharged and file suit if they don't complete the plan? That's an option, but we have not found that recoveries are really done through that. The best way to recover on the bankruptcies are finding those exceptions and other ways to proceed. So the first thing to look for is, was the claim and the incident for the claim included within the bankruptcy? And we do that by looking at the dates. If the date of the incident itself is after the date of the bankruptcy filing, then it's not going to be included in with the bankruptcy plan. If the date of the incident is before the bankruptcy filing, it will be included. So if it's included in the plan, it's going to be discharged. If it was post-petition, so after the date of the bankruptcy filing, then you're going to be able to get permission from the court to proceed to recover on the subrogation claim. So if the claim falls within the bankruptcy, there are still options for you to try to proceed to recover. And one of those is looking to see if there are any additional parties that you can recover from. Now, something called an automatic stay, which is basically a freeze on doing any kind of recovery efforts, occurs for the bankrupt party and is sometimes applied to the additional parties. But you can get permission from the courts to proceed against the other parties that didn't file bankruptcy by clarifying, hey, this is an additional party. They aren't really part of the bankruptcy estate and the people that filed bankruptcy. It's really separate and distinct. In those circumstances, you would file what's called a relief from stay to explain, hey, these are different parties. I can still proceed against this other one. When the court gives you permission, you could proceed with your lawsuit, your collection efforts, the same as you would if the bankruptcy wasn't filed. Another way to proceed if a party has filed bankruptcy is to look and see if there was insurance, because insurance payments are not considered to be part of the bankruptcy estate. If there isn't a liability issue, you should still be able to contact the opposing carrier and they will issue payment despite the bankruptcy. Sometimes they don't even know about the bankruptcy, but for sure, if it's not supposed to be part of the estate, they should be able to pay. Now, you're not going to get any money in excess if there are limits, because you won't be able to recover from the tortfeasor directly if they're the one that filed bankruptcy. But bankruptcy doesn't start the process of recovering from an insurance carrier. What you have to keep in mind is if liability is disputed by the other carrier, it's a different process to be able to proceed in litigation to recover the money against the insured carrier. In that circumstance, you have to file something that's called an adversary proceeding, which is basically a normal lawsuit inside the bankruptcy lawsuit. And that is often not contemplated by any contingency fee agreement that you would have with somebody pursuing a subrogation claim. And there are going to be additional fees associated with pursuing the bankruptcy within the federal courts of the bankruptcy. So keep that in mind as you're proceeding. It might be a different economic decision as to whether to proceed if liability is disputed. Another exception to the bankruptcy would be whether there's a DUI or an intentional act that is involved. And if somebody is driving under the influence, it's automatically something where you can proceed to recover by filing a proof of claim within the bankruptcy, because everyone understands that it's an exception to the bankruptcy discharge. But if it's an intentional act, it's not as automatic, and you may have to proceed within that adversary proceeding that we talked about before with regard to insurance, where it's that lawsuit within the lawsuit. And in those circumstances, you have to prove intent and causation. So if I'm a subrogation claims professional handling a subrogation recovery and I run into a bankruptcy, here are the things I'm going to look for once again. Is it a Chapter 13 or a Chapter 7 asset where I can file a proof of claim? If it's a Chapter 7 no asset case, does the claim fall within the bankruptcy itself, or was the incident after the bankruptcy was filed? Are there additional parties to proceed against that aren't part of the bankruptcy estate? Are there insurance proceeds that I could access that won't be part of the bankruptcy estate? And does the original incident itself involve a DUI or an intentional act that would be accepted from discharge? Please feel free to contact us if you have any questions or concerns. I'm Kim Rathbone. That's the long and short of it.